Hi, I'm Mike Sheridan, bankruptcy lawyer with Atlas Law Firm. I recently did an interview about the bankruptcy process in Minnesota.
What are the different ways to file for bankruptcy?
There are several different ways to file for bankruptcy. The Bankruptcy Code, which is the body of bankruptcy laws, is divided into various chapters. Each of those chapters features a different type of bankruptcy. There are a few different chapters. The two main ones for consumers are Chapter 7 and Chapter 13. Chapter 7 is the classic bankruptcy that most people recognize. It's preferred by most because it's relatively quicker and easier to complete. Once your case is filed, it takes about 3 months to be completed, and then once it's completed, you can start your life over again without all these debt concerns. On the date your case is filed, the protections go into effect immediately. It's called an automatic stay. The automatic stay prevents any collection action from any of your creditors. The automatic stay will stop all the calls and the collection letters and any kind of garnishment or repossession that might be happening. About a month later, you must attend a mandatory meeting called a 341 meeting, or sometimes called the meeting of creditors. This is technically where the creditors can show up and ask questions about the information in your petition. They typically don't show up because most of the information is right there in the petition for them. So the meeting typically ends up being a meeting between you, your attorney, and the trustee. The trustee is simply another attorney hired by the court that sits on the other side of the table and conducts some due diligence. They're going to ask you questions about your assets and your transfers if that's applicable. If you've hired a good attorney, that attorney will have walked you through those questions before your case was even filed so that you can understand if there are going to be any issues. After that meeting, the court gives the creditors a 60-day window to bring any objections that they may have to you getting rid of their particular debt. Your attorney can advise you to take steps to ensure that you don't have any of those objections raised in your case. After 90 days, the court issues that order for discharge. The order for discharge is a piece of paper that says your case is permanent and successful, that your debts have been discharged, and so your life goes on.